Welcome back to the program. This is Kivumbi 2017, right here on KTN News at exactly 9:27. Now let's recap our top story this morning. In the National Super Alliance, the Independent Electoral and Boundaries Commission, its chairman Wafula Chebukati and President Uhuru Kenyatta are expected to file written submission to the Supreme Court. Uhuru, IEBC and its chairman beat the last night's deadline to file responses to the Raila Odinga petition. Uhuru maintains he won fair and square due to the Jubilee campaign strategy, while IEBC maintains that the August 7 election was conducted in accordance with the law, that the voters chose the winners and not the commission. Of course, that story forms the basis of our discussion this morning. Once again, let me reintroduce our guest here in studio. And on my immediate right, we have a political analyst, Ken Ambani. Then we have Nelson Harvey, who is a lawyer. And on the far end, we have Oliver Mutai, who is also a lawyer. Many thanks, gentlemen, for joining us at this hour.
Thank
Harvey you. And your colleague there, I'm sure you're having a good time because, we're going to be treated by, these legal jargons, all these phrases from the Supreme Court. So let me just begin with this, Harvey. Today, we do expect both NASA and Jubilee to file their written submission.
Yes.
I'm sure Kenyans are watching, they're wondering what this is all about, because NASA have already filed the petition. Was it on Friday? Last Friday.
Yes.
And then Jubilee did that last night. So what is this written submission all about?
Now, because of the time constraints that the Supreme Court suffers, it does not permit a hearing where people will go to the witness box and adduce evidence in support of their case. You remember in the High Court, that is what prevails in respect of an election petition. Then thereafter, arguments are made in writing. But in the Supreme Court, the case will be heard substantially on account of the affidavit that has been put before the court. And then to conserve on the use of time, all the parties have to reduce their case, their arguments, into a written form, and that is what we call the written submissions. It is on the basis of this that the court will now sit and permit the parties to just indicate within a short period of time what are the key points that the court should pick from what they have written. And that is intended to ensure that time is conserved.
So basically it's a summary of all this.
Yes, it's a summary of the arguments. Yes.
Now, Oliver, there's something else again. They're saying according to the timeline today, on Saturday at 9 a.m., NASA is going to file a rejoinder to submission, after which the pre-trial conference starts. In layman's language, what does that mean?
The filing of the rejoinder of the submissions means that they are adding to what they had done initially. And they are doing this before the pre-trial meeting, because in the pre-trial meeting you are discussing on and developing the issues which will be dealt with, and the process and the modus operandi of the case going forward.
Okay, before I come to you, Ambani, let me just deal with the lawyers first here. And there's something to do with sub judice here, Harvey, and it's something that has made a lot of political analysts, legal observers, as well as journalists to be a bit jittery when it comes to discussing matters to do with the presidential petition. And let me just get a quote here from some of the statement that we got from the Supreme Court. They're saying they've ordered parties to the Kenya's presidential election petition, their agents, supporters, and the public to stop discussing the case, nor the judges, pending the dissemination of the matter expected on September 1st. I have two questions for you. First, is it in order for the Supreme Court as a bench to order this kind of statement? And will they even get time to watch news in the first place, because they have a lot in their hands?
It's very surprising how actually the judges of the Supreme Court came to discover that this case was being discussed in the media and the social media. I remember when some of them were being interviewed for their position, they said they don't have Facebook accounts, they don't have Twitter accounts. In fact, one even said he doesn't watch television. Now, it confounds the mind how they're able to make that directive. But anyway, let's go back to the point. The judges have cited sub judice as the reason as to why they want to prohibit this discussion. Now, the term sub judice is a Latin dogma that means under judgment, meaning that we, as the court, are looking at this issue, so don't make a determination on it. And in the medieval time, actually, it meant only that that the Latin judges were looking at this issue. So don't take action. Don't make a step in respect of that matter, because you'll preempt what we're doing. Now, fast forward, when the English common law started growing, they adopted the same doctrine. Now, the doctrine was also transported to the English colonies, in particular the United States and all the other Commonwealth countries. Now, when it reached the United States, it was torpedoed by the first issue. It was the first amendment in the United States that indicated the right to express yourself, the right to talk about something, including that which the judges are talking about, cannot be curtailed. So as we speak right now, sub judice does not apply in the United States of America. It has been relegated to the rules that confine lawyers to argue their case in court. Now, other parties are not precluded from discussing the matter. And even the lawyers in court can discuss it, provided that they do not ridicule the court or undermine the authority of the court. Now, that is as regards the United States. Now, if you go back to England, where we borrow most of our law, the term sub judice has been abolished. It's not there. And it's been abolished on account of the 1981 Contempt of Court Act, which essentially determines the manner in which parties, the general public, and the advocates will handle an issue that is pending before the court. So we don't have sub judice in England. Now, here in Kenya, last year we enacted the Contempt of Court Act, which also now deals with the issues that are before the court. And in essence, the Contempt of Court Act is quite clear. You shall not intimidate or harass a judge hearing a matter. In essence, that power is to be exercised within the confine of the proceedings, inside court. Yes. You can't just throw an order to the public and say you are prohibited from hearing this matter. So even in Kenya now, we have abolished sub judice. You go to South Africa also, sub judice has been abolished. Now, I think it is with tremendous respect that we need to address the court on this issue. There is a fallacy that the Chief Justice, as the administrator of the judiciary and as the Chief Judge, is well versed with the law. Let's debunk this mystery. Not so long ago, about 3 years ago, we saw Chief Justice Dr. William Mutunga give a directive that had the effect of ensuring that judges in the Environmental and Land Court, judges in the Employment and Labor Relations Court, had matters that were within the confine of the criminal division of the High Court. And you see, the Constitution was quite clear that that should not happen. But the Chief Justice then did not see that. The judges who handled these matters did not see that. The state councils on the part of the DPP who were handling this matter did not see that. Two advocates in the coast raised the issue and they were brushed aside. They said, no, this is nonsense. We can hear this case. But when the issue finally came to the Court of Appeal and the Supreme Court, it was decided that, look, that was a wrong decision. With what consequence? 2 years of judicial time, billions of shillings, and the liberties of individuals had been interfered with. So to that extent, it is my humble view that even as we trust the judiciary to undertake its role, I think the judiciary should stop taking Kenyans for granted. I think basically you've given us a green light to discuss this matter. Before I come to you, Mutai, let's link up with a senior political reporter who's coming to us live from the Supreme Court, with Patrick Amim, of course. Now, Patrick, good morning.